Amendment.
Resuming debate, the honourable member for Sherwood Park, Fort Saskatchewan. I just want to remind the member that he has about 4 minutes and 30 seconds, and the balance of his time will be returned to him when this issue comes before the House again.
Thank you, Mr. Speaker. I appreciate the opportunity. I will be splitting my time, and I want to discuss specific aspects of the legislation today. On Monday, I will have an opportunity to talk about some underlying philosophical questions. And I want to be clear, Mr. Speaker, that I do not believe in an all-or-nothing approach. I and many of my colleagues who have broad philosophical concerns about what is happening here are still willing to vote in favor of legislation which does not recriminalize euthanasia if it advances positively in the direction of saving some lives, especially minimizing the risk to vulnerable persons. But this legislation does not contain meaningful safeguards. Without amendment, it will protect no one. Now, Mr. Speaker, we know that this law has written exceptions, but it has exceptions to the exceptions, and may I say exceptions to the exceptions which are not at all exceptional. This legislation has a requirement for the provision of written consent, but if the person cannot provide written consent, someone else can do it on their behalf. This legislation prescribes a waiting period, but the waiting period doesn't apply in the event of possible imminent death or loss of capacity. So much ambiguity here. The government has said that mental illness is excluded, but the legislation clearly says in Section 241(2)(2) that physical or psychological suffering qualifies a person to seek premature death. Now, the legislation says that death must be reasonably foreseeable. Well, may I say that death is reasonably foreseeable for all of us. It is those who think that death is not reasonably foreseeable who probably need the medical attention. Why not put in terminal? Mr. Speaker, when I was learning to drive, my mother thought that death was reasonably foreseeable every time we got in the car. That is no criteria. Now, there is a requirement that 2 physicians sign off, but given the huge ambiguities, doctors are liable to have a wide range of interpretations of the rules. Obviously, estimates are that there are 77,000 physicians in this country, and the likely practice of doctor shopping will ensure that almost anyone who thinks they meet the woolly and ambiguous criteria can find somewhere 2 people who disagree. The member for Victoria said earlier today, this is something doctors do every day. No, it isn't, Mr. Speaker. Doctors do not take life every day. This is fundamentally different from the normal practice of medicine. And when you have so many different doctors and opinions to choose on, these aren't effective safeguards. Now, given these 5 comically ridiculous exceptions to the exceptions, there is no doubt that detailed provincial legislation or regulation will be required in every case. So it's not at all clear to me what this law is supposed to accomplish. But further, there are 2 key areas where the prevailing rules under this law will leave us demonstrably worse off than Carter alone. First of all, there is a terrifying clause in this bill which says that if someone kills someone else but can demonstrate at least beyond a reasonable doubt that they have a reasonable but mistaken belief that the criteria applied, then that person cannot be penalized. You find that 241(6). So you can kill someone who didn't consent but escape prosecution on the basis of reasonable but mistaken belief. Whatever is done, I implore this government to take this very dangerous section out. This is going even beyond the Belgian model. Now, secondly, this legislation provides no protection for conscience rights, despite the court's clear statement that nothing in this decision required particular healthcare practitioners to be involved, and despite the clear assurance of the Canadian Medical Association that access does not require taking away Section 2 conscience rights. This legislation, Mr. Speaker, constitutes a perfect storm. Ambiguous criteria, no advanced legal review, no conscience protection, allowances for doctor shopping. These aren't meaningful safeguards at all. The bill leaves patients, seniors, and the sick, the disabled, vulnerable to error and systemic abuse. We've seen this in Belgium before. I've quoted the studies during questions and comments. We don't want to go down this road in Canada at all. Now, the government must introduce simple amendments to this legislation which define the criteria more clearly, which address the problems I've mentioned, which introduce an effective system of advanced legal review. As I've said, a person seeking hastened death should require the sign-off of competent legal authority. One such model could involve the use of consent and capacity boards, or even some kind of judicial review. Again, need not be onerous. Now, this process need not be complicated. It would ensure that someone is not accidentally killed, and then their killer's able to hide behind the ambiguous criteria of reasonable but mistaken belief. Mr. Speaker, we can't save every life today, but it's better to light a candle than to curse the darkness. Too many, from my perspective, have spent too long just cursing the darkness. Let's amend this bill. Let's fix this bill so that we can get the work we need done. Thank you.